Apologies, ladies and gentlemen, but that is what happens when technology takes away all your preset passwords. You got to figure out how to get back in. All righty. Good morning. This is November 12th, 2024. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is our jail and arraignment calendar. So I'll call the arraignment calendar first. This is our 10 a.m. calendar. I'll call the arraignment calendar first, and then we'll do the jail and probation cases. Monty LaQuavius Hardage. Monty LaQuavius Hardage. May I see the courtroom, please?
Good morning, Your Honor.
Good morning. Last call for Monty LaQuavius Hardage.
The same removed for a bench warrant and a bench warrant.
All right, so this was continued from a previous calendar, and Mr. Hardage was under a different name. Can somebody remember? I think it was Moss. No, Anthony Moss. Was that it? Is this that one?
Yes, it's that one, Judge.
Thank you. Can't sign in, but I can remember some stuff. Ooh, all is not lost. All right, so bench warrant, bond forfeiture. Next is Chucky McCormick.
Judge, Mr. McCormick is in the courtroom. I'll have him approach the camera here.
All right.
Stand right here. She can hear you. If this screen goes off, she's still right there. She can still hear you.
Mr. McCormick, you're before the court for driving on a suspended or revoked license and no license. Do you currently have a license, sir?
Yes, ma'am. Yes,
all right. Ms. Hagler, do you have a recommendation for Mr. McCormick's case?
If he has a license, do you have it on you, which you can provide a copy so I can just double check on my end?
Yes, ma'am.
You have it on you?
I have my old license. I just went down to the DMV, DDS, down off 85 to have it renewed to my new address. So they supposed to send me one in the mail. So I did have that done so I could vote. So now I got my old license here in my wallet.
So you don't have any like paperwork or temporary one until the new license gets to you?
No, ma'am. I'm just waiting on that to come in now.
Yeah, usually they give you a piece of like a copy paper.
That copy paper, I don't have that one there. I left it in my wife's car. It was out this weekend. I just forgot it in my car. But I didn't know I needed to bring it to court.
Okay. I should be able to do the research with what you have. I'll send someone down to make a copy of it for me. So give me 1 second. I'll send someone down.
Okay. Thank you, Mr. McCormick. Thank you, Ms. Hagler.
Yes, Your Honor.
All right, Jose Luis Rodriguez, Mr. Handelsman's case. Jose Luis Rodriguez.
Yes, ma'am.
Okay. All right, and Mr. Handelsman? Is Mr. Handelsman here?
I don't see him on Zoom, Judge, and I don't think he's in the courtroom at all either.
I know we moved this case. I'm trying to remember why. Oh, we moved it for a plea to today. Yes. All right. So, Mr. Rodriguez, if we hold on for a second, let's see if your attorney comes up. And also, if you could like mute your device and call him to remind him that he has court this morning.
I spoke with his paralegal on yesterday. And last time I heard, he was in a car accident, a really bad car accident on Friday, I believe. Ooh. And she hadn't heard from him back. So, because I had called to see if we were still on for today, right? And she said that she hasn't heard from him back. So I don't know exactly what was going on. But she was like, "You're still on for Zoom, so just report, and I'll let you know if I hear back anything." So that was the last thing I heard from her.
Has anybody from the clerk's office gotten anything from Mr. Handelsman's office? I'll confirm you, Judge. Let me check. All right, thank you, Miss Val. All right, so Mr. Rodriguez, we'll be right back with you. Okay, just mute your device for me.
Excuse me, Your Honor.
Yes, ma'am.
It appears Lister and Holt filed an entry on this case. 11/5/24.
You all took the. I thought they had been on there before, but Handelsman came to court the last time to do the plea.
Right.
Mr. Lynch,
Your
did y'all
Honor,
do an entry on Rodriguez or some other case?
I
Because
believe-
Ms. Arnold said she sees one for November 5th.
I had just, the only thing I was going off of was the calendar, and it appeared that he was represented by private counsel.
He is, to my understanding.
But I don't think we would have filed an entry unless he would have come to court. And
Yeah,
said,
I think it's still Mr. Handelsman's case.
Yeah, there's an entry from you all from November 5th. So I don't know if that matters, but it's in there. So I don't know if that was an accident.
Yeah, y'all sent me a bunch of appointments. That might have been one where the wrong name got on the paperwork.
That's possible. I don't see why we would have submitted an appointment for someone represented, but if we did that in error, that is certainly our mistake. But Mr. Rodriguez.
Yeah, it's Mr. Handelsman though.
Seems to think that he has a private attorney, so I would defer to that.
Well, we'll try and Ms. Val is verifying with his office. The next case is Oscar Ortega Correño. Oscar Ortega Correño. Ms. Tolles, my accent is not great, so if you could sound for Mr. Ortega Correño.
Correño is the second last name, Your Honor? Good
Yeah,
morning.
I have Ortega, Oscar Ortega Correño.
But I think this is part of the same case. This is it's the same case. So I think it's part of Mr. Rodriguez's case.
Oh, okay, I'm sorry. They cut it off and put the case number at the top of the page. All right, you're right, from previously. So this is still Mr. Rodriguez's case.
Yes.
Well, let's try the jail cases now. Is there anyone on the jail case who needs the assistance of Ms. Tolles? I see a Bruce Ricardo Otero Reyes.
She speaks English fine. He does not.
Okay. All right, thank you, Ms. Tolles. We're gonna go ahead and let you assist other judges.
All right. Thank you so much. You all have a great day.
You too.
You too.
All right,
Thank you.
so that concludes the call of the arraignment calendar. We'll wait to hear about Mr. Handelsman. Mr. McCormick is having his information verified. Oh, Mr. Rodriguez? Mr.
Yes,
Rodriguez?
yes, ma'am.
This is why he's not here. Y'all are scheduled for December 6th at 10 a.m.
Oh, December 6th. Oh, okay.
Yes. So you'll be back on December 6th at 10 a.m.
December 6th. At 10 a.m.?
Yes. And I hope Mr. Handelsman is doing okay. Check with his office to make sure he's all right.
Yes, ma'am. Would it be the same code
Yes,
and
sir.
password?
Very same login.
Oh, okay. All
right.
right.
Thank you.
Am I good to go?
Yes, sir. Take
All right.
care.
Thank you. You too. Enjoy your Thanksgiving.
You too.
Bye-bye.
All right. So that takes care of that. Then the jail calendar. Jasmine Matea Collier, that's a petition.
Yes, Your Honor, it's a probation revocation.
Okay. Has anyone in the courtroom spoken with Ms. Collier?
We spoke with Ms. Collier on the probation calendar. Your Honor, I spoke with Officer Carmichael. Given the basis of the recommendation, I'd like to speak with Ms. Collier briefly, and I think we'll resolve this.
Okay, no problem. Nicholas James Dewberry.
Mr. Dewberry was not brought up today. I think, is he having health issues?
They're having issues with the doors.
The jail's having issues with their doors. He wasn't able to be brought up.
Okay. All right, Anthony Jamel Jones.
That's a plea to negotiated plea, Your Honor.
Remy Martin, LaShawn Jones. This is a petition.
And the state is ready, Your Honor, to proceed forward. The officer is on.
Judge, the defense is ready as well. Of course, as the state is aware, hearsay is not admissible in a probation revocation hearing. So, not that, at least that's my contention.
Okay.
I would disagree, but the arresting officer is on. How's that hearsay?
Well, we can just go forward with the hearing. And we can.
Can we do that, please? Amara Miller.
Is she accepting her offer?
Judge, I believe she's going to accept the negotiated plea. I just need to verify one more detail with her.
Okay, Bruce Ricardo Otero Reyes.
I spoke with Mr. Reyes, Your Honor, and that will be a negotiated plea this morning. The state, the defense does have one contention to make on one of the two charges.
All right, and the next two are petitions. Teagle, Patricia Teagle.
Your Honor, I believe Mr. Lynch spoke with Ms. Teagle, so I'll let him.
All right, and then we concluded Mr. Jordan's cases yesterday, so I didn't think that was a petition. I think that was just that that case has been closed because we did that plea yesterday for Jordan Antoine Wilson.
That sounds correct, Your Honor.
All right. All right, so
If
are we ready?
I know that we're ready to go forward right now with Mr. Otero.
Okay, let's bring him out, bring him out.
Just let me talk, but she's going to ask you some questions. First, do you need an interpreter? No. Okay. I'm just, yeah, with that.
Thanksgiving, man. So I need to see my problem.
We're ready to proceed, Your Honor.
All right, raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
100% true. Yes, ma'am. Yes,
You
Your
can put your hand down for me, sir. You're before the court on State of Georgia versus Bruce Ricardo Otero Reyes, 2024 CR 08860 for counts 1 and count 2, theft by taking. You're represented by Attorney Taz Taylor, who's with you at the podium. Do you, Mr. Taylor, what does your client plead before the for the offenses before the court?
Your Honor, my client pleads guilty to the theft by taking, count 1. Per the accusation, it's charged with 2 counts by taking, but there was only a single incident.
Okay.
And that's
so is the state no process in the second one?
Ms. Hegler, if you'll check that.
The state was not, pursuant to police report, the defendant took funds on 2 different days.
The accusation says.
Yeah, July 1st and July 2nd.
I read it as on the 2nd day of July.
The state is not, Your Honor. Again, the defendant took money on 2 separate days, and it's
what's the accusation saying?
In the accusation,
Mr. Taylor, read the accusations for me.
For count 1, with the offense of theft by taking for the accused on the 2nd day of July in Clayton County, the defendant on or about July 1st did unlawfully take money, the property of another, Don Chang. Count 2 says for the accused on the 2nd day of July 2024 in Clayton County, the defendant on or about July 2nd. So the first count says on the 2nd day of July, he did this thing on or about July 1st. The second count says on July 2nd, he did this thing on or about July 2nd.
Okay, yeah, I see the,
Okay, I'll grant the
Confusion in the
demurrer as
first
to
one.
count 1.
I'm sorry, Your Honor.
I'll grant the demurrer as to count 1, count 2 remains active. Did you wish to enter a guilty plea of, to count 2?
Yes, Your Honor, we're entering a guilty plea to count 2.
All right.
And for Ms. Hagler, I understand that restitution should be the total amount between the 2 charges because there was a full amount. We will stipulate to that.
Yes, okay, yes, that's correct.
All right, so by entering a plea of guilt, the court has granted a demurrer as to the accusation and on count 1, count 2, guilty plea. By entering a plea of guilty, Mr. Otero Reyes, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor. Yes,
All
ma'am.
right, factual basis recommendation, please.
Yes, Your Honor. On or about July 2nd, 2024, at Officer Sergeant Broughton was dispatched to 6622 Georgia Highway 85, Riverdale, Georgia 30274. This is also known as the Angie's Beauty Supply in reference to a theft. Upon making contact with the store owner, Mr. Dong, D-O-N-G, Chang, C-H-A-N-G. He stated that on July 2nd at approximately 8 p.m., the defendant took cash from Monday and Tuesday sales. He also took all of the change and coins out of the money box and took all of the cash out of the office. The total amount of funds taken is $1,165 from the store. Mr. Chang did advise that video footage was also used in providing evidence as well regarding the theft by taken. Your Honor, at this time, the state's offer is 12 months probation, 40 hours of community service, a fine of $200. The defendant is to complete the theft prevention course. I'm sorry, this is for count 2, because count 1 has been dismissed. And the defendant, we also requesting restitution to the victim, Mr. Dong Chang, in the amount of $1,165, excuse me. And the defendant is to stay away and to not return to 6622 Georgia Highway 85, Riverdale, Georgia 30274, which is also known as the Angie's '(S) Beauty Supply.
Okay. Excuse me.
Bless you.
All right, Mr. Taylor, anything on behalf of Mr. Otero Reyes?
Nothing further from the defense, Your Honor. Just ask that you accept the negotiated recommendation from the state. Bless you, Your Honor.
Thank you. So, how old are you, sir?
22 years old, ma'am.
Mr. Reyes, I'm gonna need you to do better. This person trusted you to work for them and you ripped them off, and that's not a good idea. That's not a good deed. You understand? The whole point of having to working with somebody is they're putting trust in you. And if you break that trust, there's going to be very few people who want to put you in that position again. And most of the time, whatever you took, the cost of it, the jail time, the money that you're going to spend, the probation, all of that is more than what you took. You're going to always pay back more than what you actually benefited. All right, on count two, I'll sent you to 12 months probation, 40 hours of community service, a $200 fine. That'll be $298 with the surcharges. Theft prevention course, restitution in the amount of $1,165, and you're not to go back to 6622 Georgia Highway 85, Riverdale, Georgia, Clayton County. Do you understand all of these things, sir?
Yes, Your Honor. Yes, ma'am.
All right, so the quickest way to get rearrested is to fail to complete your probation reports. If you don't show up for probation, you'll be right back here in the Clayton County Jail, and it is not a safe place. So I want you to understand that you risk more coming back here than you do out there. So you understand me?
Yes, ma'am. Yes, Your Honor.
All right, you can go back with the sheriff's office. One second. All right, I'm back. Sorry. All right, are we ready? What are we ready on? We ready on the hearing? Because we can do that.
Judge, we're ready on the hearing. We're also ready, I think, on Anthony Jones, Amara Miller, and I think we're ready on just about everything, Judge.
All right, well,
Your Honor,
let's
I have an announcement on McCormick whenever you're ready.
yes, I'm ready.
The state's gonna null cross that case.
All right, so Mr. McCormick, your case is going to be null pros. That means it's going to be dismissed. Please make sure that you keep all of your documents in order, that you are required to operate a vehicle, and you're free to go at this time, sir. Stay safe.
Thank you very much.
Thank you. Thank you, Mr. Hagler. Can we do the hearing on
Jones,
Mr. Calendar?
the young guy, was it Remy or Remy?
Mr. Remy Martin Jones?
Yes, Your Honor.
Let's go ahead and do that, and that way we can get the officer back out.
Officer Jusius, can you please turn your camera on? Hope I said it right. Jusius?
Yes, you said it right, ma'am.
Okay, perfect. Thank you.
Give me one second. Let me turn on the camera. A second.
All right.
Your Honor.
Yes.
Well, I guess we'll get
Yes.
started. Stand right here.
Bring it up a little bit closer to you. Okay.
Just check.
And this is Mr. Remy Martin LaShawn Jones.
Yes, ma'am.
We're gonna talk.
All right, so this is the hearing for the petition for revocation of probation for State of Georgia versus Remy Martin LaShawn Jones, case 2023 CR 05863. Defendant was entered a plea before this court for criminal trespass on the second day of May 2024. He was sentenced to 12 months on probation. He has 5 months and 19 days remaining. His sentence was not told. It is alleged that he violated the law by having the new offense of battery family violence on October 7th of 2024. He failed to complete community service. He has documented 4 hours as of September 9th of 2024, and he failed to pay. He is currently $320 in arrears. Mr. Jones has requested a full hearing, and Mr. Officer Julcius, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand out. Your witness, ma'am.
Thank you, Judge. Please say your first and last name for the record.
I'm Officer Julcius with the Forest Park Police Department.
I'm sorry, what's your first name?
Officer Julcius.
Your first name?
Oh, Valandi, Officer Valandi Julcius.
Okay, please spell that for the record.
The first name is Valandi, Valandy. Last name is Julcius, Julceus.
And Officer Julcius, excuse me, how are you employed? Excuse me. How are you employed?
I'm employed with the Forest Park Police Department.
And how long have you been employed with the Forest Park Police Department?
For 2 years.
Okay. And were you employed with the Forest Park Police Department on October the 7th of 2024?
Yes, ma'am.
Okay. And are you post-certified and credentialed?
Yes, ma'am.
And are all of your credentials up to date?
Yes, ma'am.
And were you post-certified and credentialed on October the 7th of 2024?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And did you have arrest powers on October the 7th of 2024?
Yes, ma'am.
And were you on official duty and working in your official capacity on that day?
Yes, ma'am.
And on October the 7th of 2024, were you dispatched to 1058 Phillips Circle, Forest Park, Georgia, 30297?
Yes, ma'am.
And what county is that address located in?
Clayton County.
Thank you. Let the record reflect that venue has been established, Your Honor.
Record shall reflect that.
Thank you. And is this a residential or commercial location?
That's a residential.
And what was the nature of the call?
A disturbance call.
I'm gonna object to hearsay at this point. Judge, there's a dearth of case law that supports the fact that hearsay is not admissible in probation revocation hearings. And neither does the client also has the right to confront the witnesses against him. So this will be my first of many hearsay objections I'm anticipating.
Well, Your Honor, the officer was responding as part of his duties, as part of an investigation to this location. So,
right. But the question asked for.
What was the nature of the call?
Okay, we can go on to where you get into the hearsay.
All right, what was the nature of the call is not hearsay. So go ahead, you can answer that, sir.
Yeah, I was dispatched to that location in reference to a disturbance call.
Disturbance, okay.
Yes.
And upon during that call, was there anything specifically said about the disturbance?
Objection, hearsay, calls for hearsay.
Your Honor, again, it's going to the officers responding to the incident location.
He's asking for a statement for the truth of the matter asserted in that statement. That's classic hearsay. There's no exception noted. Calls for hearsay.
Sustained.
Upon your arrival, did you make contact with anyone?
Yes, I did. I made contact with Zena Jones, Remy Jones, and Zakisha Leon.
Okay. So you said you made contact with Zena Jones, you said Remy and Zakia.
Yes, ma'am.
When did you speak to Remy Jones?
Yes, ma'am.
Okay. And what did you learn doing your
Objection
communications?
calls for hearsay. She's asking for a statement, even if she doesn't say what did she say, she's asking.
Wait a minute, wait a minute, wait a minute, wait a minute.
He's a defendant, Your Honor.
Asked if he spoke to Remy, correct?
She asked what did you learn from speaking to Remy, which is calling for Remy's statements, which is hearsay.
Admission by a party opponent.
Yeah, Remy's the.
No, Remy is not. You're asking for my client statements?
Yes, he's Remy.
That's his name.
All right, okay.
And thank you, Judge. And what during your communications with Remy, what did you learn?
I learned that when I confronted Remy of what's going on, he stated that the victim at the time, her name is the victor, Miss Jefferson, Andrea Jefferson, assaulted her mother. Well, his mother, due to the fact that they got into a verbal altercation about her not being able to stay inside of the house.
Okay. Did you speak to the victim in this case, Miss Jefferson? You said.
Yes, I spoke to Miss Jefferson, Andrea Jefferson, after the fact.
Excuse me.
And when you spoke to Miss Jefferson, what was her demeanor?
When I spoke to Mr. Jefferson, she was upset. She was she stated that she was assaulted.
Objection, hearsay.
So when I spoke to,
we will argue present sense impression. The victim is describing and also state of mind, her present state of mind. She's describing the incident to the officer as well as her state of mind at that time.
Judge, this testimony violates my client's due process rights under the Confrontation Clause, which does apply to hearsay, which does apply to probation revocation hearings. It is hearsay. It's not admissible. There's no exception noted to the Confrontation Clause. She's not here. If the state wants to present the statements of the alleged victim in this case, that person needs to come and testify and be subject to cross-examination.
Thank
Thank
you, Judge. So you said her repeat, what was her demeanor?
She was highly upset. She was highly upset.
Okay. Was she crying?
Yes, ma'am, she was crying.
Was she hysterical?
Yes, ma'am.
Did you notice anything else about Miss Jefferson's demeanor?
She appeared to have several visible injuries, marks on her body, on her face.
So you observed visible injuries to her body?
Yes, ma'am.
And I'm sorry, where were the visible injuries located?
In her face, on her face area, left, right side area on her neck, and also in her boobs area.
So you noticed visible injuries in her neck, and you said boobs area?
Yes, ma'am.
Did you notice visible injuries anywhere else?
No, ma'am. And her hands as well. I'm sorry. Yes. She also has some scratches on her fingers.
You said fingers?
Yes.
Fingers. Okay. Okay. And doing your investigation, were you able to determine how the victim sustained these injuries?
Objection calls for hearsay.
Yes, ma'am.
Well, I mean, there are other ways to ascertain something. Okay. He could have seen a video. There's lots of ways. So let's get to the response before you yell hearsay.
I would just ask that the witness not make reference to any statements that were given to him, since that's what the state is trying to get at.
Okay. Sustained to the extent that there's hearsay, but I haven't heard anything because the office hasn't been able to respond to the question. Go ahead.
Thank you, Judge. And during your investigation, were you able to determine how the victim sustained these injuries?
Yes, ma'am.
And how are you able to make that determination?
Due to verbal statements, witness.
Objection to hearsay.
Your Honor, he just said verbal statements of witnesses. He didn't go into what the statements were made.
Unless that witness is my client or there's a
Mr. Lynch, he can tell me that's how he made the determination. He's not saying what they said. He's saying that in his investigation, his determination was based on statements made by various witnesses, but he has yet to give me hearsay.
Okay.
Thank you, Judge.
Overruled.
I believe you. Okay, so you said verbal statements by witnesses. Were there any other ways you were able to determine how the victim sustained her visible injuries?
Based on what the victim was saying, it matches.
Objection, hearsay. He's going to go into based on what the witness was saying.
And then he said it matches.
Chill.
Go ahead.
To me or the officer, Your Honor? The officer.
I'm overruling the defense's objection. The witness may continue the statement he began making.
Okay. So if you can complete your statement, you were saying consistent and then you got cut off.
Yeah, I was saying based on the witness statement with what was said, the story's not matching of what the defendants were saying and what witnesses were saying. So I came to a conclusion that whatever Miss Andrea was saying was right, because based on what other witnesses were saying.
Okay, so is it fair to say that Miss Jefferson's version of what happened was consistent with the other witnesses you spoke with?
Yes.
Okay.
And Judge, I have to note my objection to hearsay. Again, she's trying to introduce statements that these witnesses said, compare them with each other, say that they're accurate for the truth of those statements, which is what she's trying to assert, is that those statements were true.
Mr. Lynch, she's essentially established is that the officer believed the statements and made decisions in the case based on those statements. He didn't say they were true, not true. He said in the way he was investigating the case. So she hasn't presented a statement for you to make an objection to. I think it's actually been rather artful. So continue, Ms. Hagler.
Thank you, Chad. And then Officer Jusius, do you see, you mentioned that you spoke with Zena, Remy, and Zakia. Do you see Remy in the courtroom today or virtual court?
I'm sorry, I muted myself. Can you hear me?
Yes. Do you see Remy in the courtroom today? Virtual
yes, ma'am.
court. Okay.
Yes.
And is he the defendant in this case?
Yes, ma'am.
And can you please describe to the judge what he's wearing and where he's standing?
He's wearing an orange suit and he's standing behind his legal attorney, and he has an afro.
Okay. A
white t-shirt underneath the suit, orange suit.
Okay, thank you. Let the record reflect, Your Honor, that Officer Jusius has identified the defendant in the courtroom.
Record shall reflect that.
Thank you. And during your investigation, were you able to determine if there were any primary aggressors?
Yes, Bill.
Okay. Who were you able to determine to be the primary aggressor in your investigation?
Mr. Remy, Ms. Zena, and Sakisha.
Why did you determine the defendant to be one of the primary aggressors?
Once again, based on what one of the witness said, and matches what the victim has said.
Okay. And on that day, did you make any arrests?
Yes, ma'am.
And who did you arrest on that day?
I arrested Mr. Remy Jones, Zakisha Leon, and Zena Jones.
Okay. And what was Mr. Remy charged with?
Battery, family violence.
Okay. And why was he charged with battery, family violence?
I charged him with battery, family violence because Miss Andrea lived in that apartment and stayed in that apartment as well.
And did you take photographs of the injuries to Miss Andrea Jefferson?
Yes, ma'am.
You take photos? Okay. Okay. You got 1 second, please.
Yes, ma'am.
Your Honor, no further questions for Officer Josias.
Mr. Lynch, do you have questions for this officer?
I do not.
All right. All right. Anything else for Officer Josias?
Not from the state, Your Honor.
All right. Officer Josias, you can be excused at this time. Thank you, sir.
Thank you, officer.
Appreciate you. Have a good day.
All right. Anything else from the state?
No other witnesses, Your Honor, from the state.
All right. Anything from the defense?
Judge, we're not going to present any witnesses. We just have argument as to the alleged violation and the proof that was offered today.
All right. Is there a recommendation from probation?
Your Honor, in speaking with Ms. Hagler, I believe 5 months and 19 days, which is the balance, should be revoked.
No, I need you to give me a minute, okay?
All right. All right. Ms. Hagler, I'll hear from you, and then I'll hear from Mr. Lynch.
Yes, Your Honor. As the court did mention earlier, the defendant is currently on probation. That probation is still active. We just had a hearing. Officer Jusilis did testify that he did respond to the incident location at 1058 Phillips Circle in reference to a disturbance. Upon his arrival, he did make contact with the victim in this new case, Andrea Jefferson. He testified that he did notice visible injuries on Miss Jefferson. She had injuries on her neck, she had injuries on her boobs and her fingers. We also learned from the testimony today that the officer did determine the defendant to be the primary aggressor in this situation. Officer did testify that he also took photos of Ms. Jefferson's visible injuries. And he also testified that the victim's statements were consistent with other witnesses that he did interview on that day as part of the investigation. And as a result, the defendant was arrested on this new offense of battery, family violence, as Ms. Jefferson did live in the same household as the defendant, Remy Jones. And so because, again, he has violated probation, which is still active, the state is requesting the judge to revoke his probation, and to revoke the 5 months, 19 days remaining. Thank you.
All right. Mr. Lynch?
Judge, the officer testified that he arrested 3 people. The officer testified that he observed injuries. The fact that my client was arrested and that he observed injuries does not meet the standard, which is preponderance of the evidence in this case. The alleged victim did not testify. There was no statements that the court, as you know, hearsay, if any did get in, has no probative value. I understand the officer made a determination that certain statements that we did not hear today were not consistent with, were consistent with one another. However, the court is left with the situation where two additional people other than my client were arrested for allegedly causing injuries or an altercation, which the alleged victim is in this case, without any statements or any evidence other than the fact that the officer made an arrest. That does not meet the standard of preponderance of the evidence. Additionally, this, in order to violate him based on allegations made by a person who did not testify, would violate his right against confrontation. The confrontation clause does apply to probation revocation hearings, Judge. So
he told the officer that the lady jumped on his mother.
I'm sorry?
Mr. Remy told the officer that the lady jumped on his mother.
But, and Your Honor, she did, or he did according to the testimony. But what you did not hear was he make any admissions as to putting hands on her. My client makes no such admissions. My client is placed in a predicament by this hearing where he would have to waive his right against self-incrimination because he still has a pending case. This is a pending case which he has the right to trial on, the right against self-incrimination, and the right to choose not to testify, and that's not to be held against him. So he made no admissions that he put hands on anybody. He did state that she jumped on his mother, who, according to the testimony, was also arrested for something in connection with this incident. And so you're left with a situation where you don't know who, and there's no evidence to get you to that preponderance of the evidence standard to show who may have caused the
preponderance of the evidence is a much lower standard than beyond a reasonable doubt. As Mr. Javaric used to say downstairs, and Judge, I understand it's a lower standard, but there's a standard. And
there is a standard, Judge.
But the officer testified that he was called to a disturbance. He spoke with all of the individuals there. One person had visible bodily injuries, Mr. Remy and Zakia and Zena, who all share the same last name, or at least Zakia and Remy share the same last name. Mr. Remy talked about the woman jumping on his mother. The woman who allegedly jumped on his mother was the one who had the visible injuries, and 3 people were arrested for battery. And so that's enough for me to make a probable cause determination that Mr. Jones is subject to having his bond revoked for violating his bond conditions.
Right. Well, we're on a probation revocation, Judge.
I mean, his probation revocation for violating his probation conditions, which one of them is to not get arrested again.
Judge, just to get away from arguing about the evidence,
okay,
before you make any determination.
Okay, let me just say this. Mr. Jones is not new to me. He's been here a lot. And I don't want to hold his past against him, but Mr. Jones is here a lot. And he's getting to be one of those people who is going to be deemed not a good probation candidate.
Can I have one moment, Your Honor?
Yeah.
Judge, my understanding is that while he may have been in front of you before, he doesn't have a history of violent charges. He, he's on probation for obstruction, is my understanding, criminal trespass. Judge, as far as the allegation of simple battery, there are additional defendants in that matter. He has a right to be presumed innocent until proven guilty. As far as his performance on probation, he has completed more hours than have been documented. He's done at least 20 hours, he tells me, and he would be documenting that with the probation office as soon as he has a chance to. Judge, I don't believe there's any allegation that he's not reporting to probation. He's had, other than this arrest, there aren't additional criminal violations that have been raised. And I understand that the court has indicated that, yeah, and, just a quick glance at his state court history, not the official version, but just looking on the website, I do not see anything violent, Judge. So to revoke the balance of his probation based on what, I disagree that the evidence met the preponderance of the evidence standard, but if it did, it just barely squeaked across the finish line, Judge. And, Your Honor, will be hearing that case.
Okay, here's the other issue, Mr. Lynch. So if I revoke and I revoke less than the balance, where does he go to? Because the other two defendants live in the home. The lady who was assaulted lives in the home, or was living in the home. I don't know where he goes that is going to keep him out of trouble until these cases are resolved.
He can speak to that, but he's telling me he doesn't have an issue staying away from the alleged victim in this case, Judge.
Why? Like, how do I know this? Because he was charged with battery family violence because she lived in the home. I don't know if she's related or if she's rooming, or I don't know all this because I didn't hear the hearsay. But my concern is this is just something that's going to reoccur. I don't have control over Zena and Zakia, but if he goes home, then my understanding is that there need to be some safeguards.
No, Judge, my understanding is they don't currently live together. The battery family violence could have been based on whether they previously stayed together. However,
that's not what the officer testified to. He said that she was in a resident of the apartment where they live.
Regardless of what the truth of the matter is as to where she resides, Mr. Jones understands that he cannot have contact with her. And I know you're clear on this, but the alleged victim in this case had nothing to do with the case he's on probation for. So
yeah, I'm not.
Previous to this, there was no stay away conditions. So he has not shown the court that he cannot abide by stay away conditions. He understands that a condition of his bond, which by the way, he is held on that misdemeanor charge with no bond, which he should be entitled to a bond on a misdemeanor, Judge.
But why did the magistrate make that decision?
Well, I'm guessing it was because he's on probation for
exactly under 1710(1). If you're on probation for something that involves, especially if it involves a possible violent offense, or if you're on probation, period, they will no bond you because you're not supposed to get another charge while you're on probation. That's the whole point, Mr. Lynch. You're not supposed to get arrested again when you're on probation.
And I understand that, Judge. However, the alleged violation, is something that he adamantly contests, and something that he has a right to a trial on, and something that he will be subject to a trial on before you. And if there were to be allegations that he violated his bond, then the state could file a motion to revoke his bond. But to revoke the balance,
But the whole point is, Mr. Lynch, is the court doesn't do double work. And if the point is that I have a mechanism for revoking bond on somebody who's not on probation, who's not been sentenced yet, who's pre-sentencing, then that's the mechanism I use. But if I have a mechanism for somebody who is currently serving a sentence, then that's the mechanism I use. A petition for bond revocation is the correct mechanism in this case. I don't have to rely on a bond revocation.
And I understand you do not have to rely on that, Judge, but I would argue revoking the balance is not the appropriate sanction in this case, not just based on the fact that this appears to be his first charge where there's any violence alleged, also based on the fact of who he is, based on the fact that he complied with probation to a great extent, that he's reported to probation, that he has started to complete his community service hours. He tells me he's got at least 20 hours completed. My client is 38 years old. He has a son with special needs. He is currently working, I believe, at Church's Chicken. Judge, he is trying to be a productive member of society. And he, you know, to revoke the balance now and have him serve more time than the state typically asks for on someone's first violent charge, you know, Judge, I feel would be overly punitive, especially considering the strength of the evidence that was presented, and that it essentially, you know, it essentially punishes him for a crime that he has not been convicted of, Judge. And so we're requesting that he be returned to probation with the same conditions or such additional conditions as Your Honor would deem appropriate, and that he be, you know, face jeopardy for this alleged offense when it comes up for trial.
All right, Mr. Jones, I do find that from a preponderance of the evidence that he's violated the terms and conditions of
Your Honor,
probation.
your camera is off. Your Honor, your camera is off.
Sorry.
Interrupt.
I hit it when I was trying to fiddle with these papers on my desk. Yeah, I do find that his probation, he's violated the terms and conditions of probation by a preponderance of the evidence. I do find that it doesn't meet the I guess the standard I would set for revoking the entire balance of probation, but he will serve 20 days. 20 days will be revoked. After service of 20 days, he's going to return to probation and continue all of the special conditions of probation.
Thank you, Judge.
All righty, I'm sending the order over.
Judge.
All right.
All right, so I'm ready to go forward on all of the other cases.
Thanks. You're okay. You're all right. You're all right.
Mr. Handelsman is on.
Hi, I'm Judge.
Hi, sir. If you can get your client on, we'll be fine. I told him December 6th because I didn't know. He said you had a car accident.
Yes,
I didn't know what was going on.
Yes, Judge, I'm homebound at this time. December 6th, what time?
I'm sorry, December 10th? Oh, I'm sorry, December 10th, Mr. Handelsman. I'm sorry. I'm just making it up as I go. My Miss Val is about to get on me.
Okay.
So December 10th. And please tell your client December 10th because I think I told him December 6th.
I will.
All right.
So same time, 11 o'clock?
Yes, sir. And I hope you're feeling better.
Thank you, Judge.
All right. Take care of yourself, Mr. Handelsman.
Thank you, Judge.
All right. We'll see you then.
Bye.
Bye-bye. All right. Who's next?
Judge, I've asked the deputy to bring out Mr. Jones, the other Mr. Jones. Step right here, sir.
All right, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
You can put your hands down, sir. Thank you. You, the state of Georgia versus Anthony Jamel Jones, 2024 CR 08763 for loitering or prowling. Mr. Lynch, what is your client plead to the offenses before the court?
Judge, he pleads no contest.
By entering a plea of nolo, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony or evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about October the 14th of 2024 at 23:06 hours, Deputy Woods with the Clayton County Sheriff's Office was dispatched to the McDonald's located at 7894 Terra Boulevard, Jonesboro, Georgia, 30236 in reference to a suspicious person. Upon his arrival, Deputy Woods approached the defendant and informed the defendant that he was under arrest for loitering or prowling due to the fact that the defendant was previously given a lawful order by the Clayton County Sheriff's Office to not return to any businesses unless it was for the sole purpose of purchasing merchandise. The defendant did inform Deputy Woods that he was not purchasing any items and that he was looking for money to purchase food. At that time, the defendant was placed under arrest. Your Honor, in the state's recommendation, 12 months to serve, 30 days, balance suspended, and the defendant is to stay away and to not return to 7894 Terra Boulevard, Jonesboro, Georgia, 30236, also known as the McDonald's.
So, Judge, my client entered a no contest plea. From reading, from hearing that factual basis, I do have some issues with the loitering at this particular business, because a criminal offense has to be particular. You can't just say don't go back to a business, otherwise that's loitering. I don't believe the sheriff's office has that power. However, my client did plead no contest, and just a little bit about the situation. I spoke to Mr. Jones when he initially came into jail, and he was not doing great at that time. That was before he got his medication. He is on medication now, and he is lucid. He understands what's going on, and he will take responsibility for any wrongdoing. A little bit about the situation. He had actually just been released with instructions to go straight to the hospital to get his medication, because that has been an issue with him when he's not on medication. He was not able to do that, and he didn't have his mother is a great source of support for Mr. Jones, but she was not available to help him at that time. And so he was apparently on McDonald's. So, I'm going to ask you to do essentially what the state is asking, except for the sentence to be 27 days, which is how much time he has already done in custody. And, I would ask the court to take into consideration the factual basis, which I know we're here about loitering, not criminal trespass, but from that factual basis, it does not sound like he was given a specific warning not to be at that particular McDonald's. And loitering or prowling, as it's alleged, has to put a reasonable person, in fear for the safety of their person or property. And he did plead no contest. I didn't hear any facts, though, that would necessarily rise to that level. Nonetheless, Judge, my client tells me he has a safe place to go. He has medication, and he has a plan to continue medication. He lives in a group home. where he has certain responsibilities that he has to maintain in order to keep that residence. And we're asking that you release him to that. He doesn't have an issue not returning to that McDonald's. That's
All right. The court is going to accept your plea of nolo. I'll sentence you to 27 days credit for time served. Balance will be suspended as long as you do not go back to the McDonald's at 7894 Terra Boulevard, Jonesboro, Clayton County, Georgia.
Yes, Your Honor. Thank you so much.
All right. Thank you. Take care of yourself, sir, and take your medicine.
Mr. Jones wishes to make a statement.
This guy's an excellent attorney. I want to tell you that the lady offered me some food at McDonald's. That's only one time. I got out of jail. I went exactly home, man. I did the right thing. I was just I was hungry, man. I didn't get food that night in the morning time. The second day, I was there the second day. That's all it was, man.
All right, Mr. Jones, I get it. Thank you. And please keep in touch with the person who's helping you. All right.
Yes, ma'am.
All right. Thank you.
Thank you, man. Thank you so much.
Take care.
Thank you, sir.
You're good.
All right, so I have, it looks like three cases remaining, Teagle, Miller, and Collier, all females. So y'all let me know when you're ready.
Yes. All right, I think Ms. Collier's coming out. This is Ms. Teagle, but I guess we can go ahead and do Ms. Teagle. That's fine. Judge,
This Ms. Teagle?
We do have Ms. Teagle. And
okay.
My understanding is that Ms. Teagle wishes to stipulate and accept the recommendation from probation.
All right. All right, Ms. Chang, this is State of Georgia versus Patricia Teagle. Ms. Teagle, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on 2020 CR 00998. You were before this court for driving under the influence and give a false name, address, or date of birth. On September 17th of 2024, you were sentenced to 12 months on probation. You have 10 months and 4 days remaining. Says that you failed to avoid injurious and vicious habits. You tested positive for alcohol and metabolites of alcohol on October 4, 2024. You failed to report to probation on October 30th, 2024. You last reported on November 5th, 2024. You failed to complete a clinical evaluation. You failed to attend AA meetings as directed, one per week. You failed to document proof of completing 240 hours of community service. You have documented no hours, and you failed to pay, as instructed, you're currently $405 in arrears. All right, and you wish to stipulate to the violations of probation. What's the recommendation, Ms. Chang?
Your Honor, probation recommends that Ms. Teagle receive credit for time served since November 5th. That's 7 days, and return to probation. She's to be tested each report and complete a clinical evaluation by November 22nd.
All right, so Ms. Teagle, your DUI was back in 2020. We just got around to adjudicating it due to all kinds of COVID and non-COVID related administrative issues. But the problem is that you had a 2020 DUI, you're just being adjudicated. As soon as I put you on probation, you start drinking, which means that you have been an unchecked alcoholic since well before the 2020 adjudication, and that hasn't stopped. How old are you, ma'am?
I'm 50.
All right. So can we just acknowledge that you're an alcoholic?
I'm not gonna say I'm an alcoholic.
Miss Teagle, stop right there.
Okay,
Miss Teagle, stop right there. Because see, when you lie to yourself, that's why you back in court in a jumpsuit when we talked to each other on September 17th, and you couldn't wait to take a drink and you got caught. I'm saying you got caught because you were drinking probably as soon as you left court. You got caught on October 4th. You couldn't even get 3 months into your probation before you started drinking again. So yes, ma'am, you can lie to yourself, but you can't lie to me. You are an alcoholic. Let's say it together. I am Patricia Teagle. I'm an alcoholic.
I, Patricia Teagle, am an alcoholic.
Okay. Ms. Teagle, are you in the health that you wish to be?
Am I in the what, health?
Like, do you think you're healthy as you could be if you weren't drinking?
Oh no, I got stuff going on that causes. I mean, I just got a positive diagnosis. I went home. My house is gone. Well, not gone all the way, but I mean everything's behind. So yeah, I went back to ways in which I had. So
okay. Well, I'm gonna just say that you probably never left those ways, and I'm gonna tell you why I know that. Because you've been struggling with alcohol, and that's why some of these things are happening. That's why you're not able to keep up with your bills. That's why you're not able to work and sustain yourself in a way that you would like to do that. That's why that things are behind. And so that's why your health is not the way it should be. Do you know alcohol is one of the biggest causes of cancer and other destructive illnesses to the body?
no, ma'am.
It is a big cancer causer. And alcohol takes the body apart. It really does. And so, Ms. Teagle, until you're willing to acknowledge that you're an alcoholic, now you said it with me, but you don't really believe it. But let me tell you, this is maybe your second, or I don't know about your record, but I know this is at least your second time in this court. First the times you came before the sentencing, and then the sentencing, and now the probation revocation, and the fact that your economic situation, your financial situation, your health situation, all of those things are in decline, but you don't think you're an alcoholic. But look around at the people who are not alcoholics. So, I mean, I get that it's easier to pretend that you're not because it makes it easier to live with it. But ma'am, until you acknowledge that you're an alcoholic and that alcohol has taken over your life, you're not going to be able to fight it and fight your way back to a normal, healthy life. You got me?
I got you.
In this space of time, even drinking, you could have been gone to AA meetings. But the reason you didn't go is because you don't want to face it. You don't want to walk into that room with other alcoholics and say, hi, my name is Patricia, and I'm an alcoholic. You don't want to face it, but you got to face it in order to get better. You have children?
I have one.
She's in a quorum, Judge.
Okay. And your child is in here supporting you through all of this. But imagine what your relationship could be with your child if you weren't drinking. Imagine how much better it would be. Imagine the girls' trips y'all could take, imagine y'all could ride back to wherever y'all wanted to go to see, people from the past, or go on cruises, or, things that at this point in your life, you should be enjoying. This is the time in your life where you should be enjoying things, not still showing up in a green jumpsuit in a jail where those young girls in there, they're crazy. They ain't playing. And at this point, you auntie or grandma. This is not the place for you. If you don't do anything else I ask you to, you need to start going to AA meetings. As many as you possibly can. I'm going to increase it to 2 a week.
How am I supposed to?
Ma'am, I don't know what you're doing now. You said everything is in decline. So how you not? If you can find a place to go drink, you can find an AA meeting. You working?
I have a job. I'm supposed to start at Wednesday. My job, the same job that I had when I got locked up before.
And you know what? they're not gonna keep taking you back. So when you say, how am I, when you drink and jeopardize your job, that's how. You drank, you jeopardize your job. But I say go to an AA meeting and you, how am I supposed to do that? Well,
I don't have the transportation. That's what I'm telling you. I'm down.
They got AA meetings everywhere. If you can walk to a church, they probably got an AA meet. You probably need to walk. Get up and walk every morning or every afternoon. Find you how you getting to work? They have virtual AA. Thank you, Ms. Powell. They have virtual AA meetings. But how you getting to work, but you can't get to an AA meeting? See, these are the lies we tell ourselves. I'm supposed to start a job on Wednesday. Okay, well, how you getting to the job? Well, I tell you what, you won't be getting to that job on Wednesday. No. You need a little bit more time.
Yeah, my daughter takes me to work and stuff. I got all this lined up.
Hold on, stop talking to me.
Ms. Teagle, if you intended to do all these things, then you would have done something I asked you to do and not done the other thing I asked you to do. I told you not to drink. I told you to go to AA meetings.
Well, see, that part right there, I told the lady that I didn't have the paperwork. The reason I missed the 30th appointment, I haven't ran from nobody. I just got a cousin that just got killed. We went when I realized and thought about the 30th, I was in the funeral at the time with my daughter. And my daughter is my witness. I've been trying to get it all back on track. I have my mental issues. I even signed up for pathways. I mean, I'm trying to get it. I do have other things that are going on mentally. It's not all about drinking. And yes, when I get upset, I do drink. But this job is gonna put me back where I'm at. I mean, everybody's working with me. I'm just asking you just to please let me get where I can go back to work. I'll do what you asked me to do, the AA. See, I didn't know nothing about the virtual AA meetings. See, I don't have any problems going because I know that when I'm stressed and when things are not going right, I spaz. I go through a lot of stuff. That's why I signed myself up for pathway meetings. That's why I go to my clinic. I went through them, asked for help. So I am trying. I'm not just out here just effing up. I'm literally giving it some effort. But it's just been things happening. I had a wreck, so the transportation was messed up. So it's not that I'm just saying him blowing it off. I do know that I have weaknesses. I'm the first person to tell you that. I'm not where I was 2 years ago. So I have made some improvements. It's just the stress and the stuff. But I've reached out. Like I was telling Ms. Chang, I've reached out. I've asked for stuff that I went to my clinic, which is Haven of Hope. I told them, I said, mentally, I'm stressing out. I even said something to them about the drinking because of the positive test and everything. They got me hooked up with my pathway. They helped me talk to the people with the job. So I have did things to make some improvement. Yeah, I messed up. I'm the first one to tell you that. But I just need you just to give me an opportunity to get back out there again. Because I'm used to having my own money. I'm used to doing what I do. I got a whole grandbaby, and I'm the first to tell you, yeah, I messed up. But like I told Ms. Chang, you could have caught me on, I told her then, pissed at me now. I've been with my daughter, I mean, the whole time, besides from after I got everything straight. So I'm just asking, just give me another chance because I got so much lined up that I know it's going to help me. And I'm not one of them, like you say, I'm 50 years old. I ain't got that much time to play with. So
that's the point I'm trying to get you to. You don't have no time to play with. You really don't. I'm older than you, and you don't have time to play with. I'm telling you.
Well, I'm trying. I got stuff lined up between me.
Okay, Miss Teagle, I'm gonna do this. Cause not for you, but for your daughter. I'm gonna do this. I'm gonna give you the recommendation that the state has, but I'm gonna tell you right now, I expect that this ain't gonna be your only revocation hearing because I don't really think that you have fully embraced this. And I think that you are still struggling. But I'm gonna go ahead. and give you the 7 days credit for time served. You're going to test at each report. You're going to do your clinical evaluation by November 22nd. If you are already involved with a organization that has helped you with your mental health issues, then you can do your clinical evaluation through them. That's fine. You don't go to it. You don't have to go to another agency if they're able to do it. And so I'm going to allow you to do this. But what I want you to know is every time you mess up, you stress your daughter out. If you think you got stress, imagine what she got. If you think you got stress, imagine how she feels. If you think you got stress, imagine how she got to keep up with you. She got to take you where you need to be. She got to worry about whether you're going to fall off the wagon. She got to worry about the next phone call and whether you're going to be okay or not. She's got to worry about whether she's got to take off from her job and come see about you. She's got to worry about her child because you say she's your only child, which means the child is her child, that's your grandchild. So she's caught in between being a mama to her children and being a mama to you. So every time you make a move that ends up in the negative, you cause her more stress.
Okay.
So all this stuff you're saying about how you trying to get yourself back on track, I'm hoping for it. I hope it happens. But what I tell you is every time you make a move that causes you to have a problem, you are also causing your daughter to have a problem. And that's not fair to her. It's not fair. Imagine the stress she's going through. Just imagine. Because she's carrying the burden of her life, your life, her son or daughter's life. She's carrying all of these. All right, that's the whole thing, and then it just disappeared on my computer. Let me retype it. But yeah, you're gonna do your clinical evaluation by November 22nd. Miss Chang, if you have recommendations for when she's supposed to come see you, then that's fine. Go ahead and let her know. And I
Yes,
just will
ma'am.
remind you, Miss Teagle, you've been going through this for a long time. We just caught you in 2020, but you've been doing this forever. That's probably why you crashed your car, just driving however. But I'm gonna tell you that you're causing stress in not just your life, but your daughter's life, your grandchild's life. Anytime that your daughter has to take care of you and do all these things for you, you're causing her stress too. All right.
All right.
So these are not just your mess ups. These are your mess ups that affect other people.
Ms. Teagle, if you'll report on Thursday, November 14th at 3 p.m.
Okay.
All right. All right, so don't forget 2 AA meetings per week. You can attend virtually, and you need to make sure that you show proof of attendance to Miss Chang.
Okay,
All right, thank you.
thank you.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
Thank you, Your Honor. This is Ms. Collier.
Give 1 second.
Yes. So 20 days. Credit for time served. Came in. Today's the
All right, Ms. Collier,
20 days.
you raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. I'm sorry, speak up.
Yes.
All right, you can put your hand down. Ms. Collier, you're before the court on Jasmine Matea Collier, 2024 CR 03692 for public indecency on the 7th day of May 2024. You're sentenced to 12 months probation. You have 5 months and 1 day remaining. Your probation was told because we lost track of you. You failed to report on June 20th and October 28th of 2024. You last reported on May 23rd of 2024. You failed to complete a drug and alcohol evaluation. All right, Ms. Collier. You're represented by Mr. Taylor with the law firm of Lister Hope and Dennis. Mr. Taylor, what is going on with Ms. Collier?
Your Honor, we stipulate to the violations as listed in the probation petition.
All right.
Here has not reported, and I don't believe she has completed the drug and alcohol evaluation. I'm not sure of Ms. Collier's housing situation. I know that she's been before you earlier this year on another case, which was pedestrian and roadway, and she had probation on that. She's not in a situation where she's committing, it's crimes against the public basically, because I believe she's homeless. It doesn't have a stable place to live that she's finding.
Are there any mental health issues we should be concerned about?
No.
I don't believe so. When I speak to Ms. Collier, she talks to me. We have conversations just fine. Certainly from a competency standpoint, there's no problem with competency whatsoever, but she talks to me much better than I talk to some of my colleagues.
Ms. Collier, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Now, Ms. Collier, let me ask you, how old are you, ma'am?
I'm 26.
How we get here, Ms. Collier?
To this state, like this point.
Yeah, living on the street, kind of pillar to post. What's going on? What got us here?
Not really sure. I think just life. I get harassed a lot, so a lot of like drama just with people hating me, and I'm triggered a lot. But I mean, and I do have a boyfriend, like, and he has been giving me rings and stuff. I'm also in a relationship, like, with him, so it's just, yeah. But lately, I've just been staying with him.
Who's the boyfriend?
His name is Adrian.
What's he do?
I'm I'm not too sure what he does, but I just know that, yeah, I'm in a relationship. I just stay with a guy, so I'm not like, we're not like really homeless, you know, like I just stay with him. He has, he stays like with his dad, I think, but we just be like everywhere. So like just living life, having fun. So I just be with him mostly all day.
Okay. Where are you from originally? You're not from Georgia.
Yeah, I'm from Atlanta.
Born and raised here.
Yeah.
You don't have any family members?
I do, but no, they take it as I'm grown. So like I'm on my own now. So I don't talk to any of them.
Any job prospects?
I have been trying to get a job. So
In doing what?
last job I tried, it was airport cleaning, but we have to go through this whole process. I went through training and everything, and then just to find out they had to do a background check, and then my probation messed it up. So, but now I'm trying to work at like American Deli or a food restaurant, because I mean I like food.
You have children?
That's gonna be easy to get a job.
I'm sorry, Your Honor, what was the last question?
You have any children?
No.
All right. So what's the recommendation, Mr. Carmichael?
Yes, Your Honor. Probation recommends serve 20 days. Give credit for time served. She was booked in on the 5th of this month and closed case.
Mr. Taylor?
Thank you, Your Honor. It's a very reasonable recommendation. I just believe that Ms. Collier has difficulty with probation based on her lack of a stable housing and job situation. Doesn't allow her to make commitments and complete commitments such as the drug evaluation. I would just ask that she be given credit for time served and released. Again, the original charge was a public indecency charge, and I believe that's generally caused by urinating in public, is where people pick that up. And her previous charge before that was pedestrian in roadway. She's not really a danger to anyone, and I just think she just doesn't have the means to get through probation successfully without being rearrested.
All right. Court's gonna accept the recommendation of probation. Defendant shall receive credit for time served for 20 days, and the case should be closed.
I understand. It's not processed out today. It's gonna be 20 days from the 4th. So we've been in.
She said like, I'm getting released today.
No. 20 days from the time of lock. And that was on November 5th. Okay, so that was 7 days ago, so you're still going to have some time remaining, okay?
How much longer do I have?
Your Honor, or Officer Carmichael, what day would that? She had some question about what day should be released.
Yeah, because they held me last time. I was supposed to get out 90 days. I was held like an extra week. So I just don't want to be held no more.
So if you've been given credit for the days you've served, let me see. I can give you an exact date. Now, keep in mind too that I don't work in the jail, so I can't really say for sure if they can get you out on the day we're going to discuss.
What's a max out date? It's if the sheriff changes it.
How long has she been in?
She's been in since the 5th, Your Honor.
Yes.
So that's a total of.
It says the 4th though. I've been here since the 4th on my badge.
You've been in since the. Okay.
I'll give her 10 days.
Okay.
Credit for time served. Yeah, I sent the order over. I'll redo it.
Sorry about that, Your Honor.
That's okay.
That's fine, Mr. Carmichael. It's just we know that the jail does things a little bit different than we do in the court.
Right. Yes, sir.
Thank you both.
Okay. Thank you.
By the way, Your Honor, that's all my cases. May I be excused?
You may. I'm gonna go ahead and send over the amended.
Yes, Your Honor. Thank you.
Yes, Miss. Are we ready on Miller?
I was gonna ask about that, whether Your Honor, could place yourself and myself and Ms. Hagler in a breakout room.
Miller?
Yes, Judge, just briefly.
Okay, one second. Let me finish this.
Miller's gonna be next, but hold off for 1 minute.
This is our last on the.
Yeah, well, then we gotta deal with some issues. Good.
Oh my God. So Miller decided that she was healthy enough to stick around.
She wants to play.
All right, hold on.
Prepared to point forward.
Judge, I did, I have Miss Miller here, but I did hear what you were mentioning, and I did want to inquire as well. I know, my understanding was that the jail had asked for an administrative dismissal on that, and I was gonna see if Ms. Hagler could confirm what I was saying. I don't wanna,
Well, just, yeah, if that's all they need, let's go ahead and do it. It's that thing where, Ms. Hagler, we had this problem last year for some reason, and it's popping up again, where if they're booked in on certain charges and then y'all accuse different charges, but they're still, they don't, for some reason, they're not getting rid of the charges that were booked in at magistrate court or changing them once y'all accuse it. And so they'll end up with charges from magistrate court and charges from the accusation, but in their system. And then they won't let the person out because there'll still be an unresolved charge.
Is it under the same case number, CR number, or no? Okay, okay.
Well, I don't
I
know.
can look
Because
into
when it
that.
comes up, I'm not sure how they, like, when they take somebody into custody, it's usually under the warrant number.
Mhm.
But they don't, when y'all accuse it, sometimes they don't get all of that wrapped up into an accusation.
Yes, ma'am. So I'll look into that.
Yeah,
That's what I
so
need to
we could
do.
just go ahead and, because we resolved his cases, so we just need an administrative dismissal and no pros on the whatever that remaining thing is, which I don't think was on
Right,
the
okay.
criminal, that I don't think that was on the CR.
well, there was a count of giving false information on the CR. There was also obstruction. The reason I'm so confident that this is an error and not a separate charge is because the magistrate court contacted our office and asked for an additional waiver. And if you look at the dates on the warrant numbers, they're all from the same date. So if it was like an old warrant with a different date, then that would be a different offense. But I believe it's from the same incident. Therefore, he resolved it. And that
Yeah, this happened quite a few times last year. And I'm not sure, I thought we had conquered it. But it seems to be popping up again because we're still getting a lot of cases up from magistrate court that are old. Like we're still getting 2021s.
Okay. Yes, ma'am. I'll look into that and see what I need to do.
Thank you. All right, Miss Miller.
Hello.
Hi, Miss Miller. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. So, Ms. Miller, you're before the court on 2024 CR 08817 Amara Miller for battery count 1 and simple battery count 2. You're represented by Mr. Owen Lynch. Mr. Lynch, what does your client plead to the offenses before the court?
she pleads guilty.
All right. By entering a plea of guilty to count 1 and count 2 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am? All right, factual basis and recommendation, please.
Yes, Your Honor. On or about October the 23rd of 2024, Officer Nathaniel Parker, while at 6234 Spine Road, Atlanta, Georgia, 30337, Clayton County, also known as the Atlanta Hartsfield International Jackson Airport. He witnessed the defendant approach the victim, Miss Deosha Roberts, while she was going about her daily janitorial routine. The defendant then, without warrant, struck the victim, Miss Roberts, in the face and pulled her to the ground, where she continued to strike the victim in the face with closed fists. At that time, Officer Parker did detain the defendant, and at that point, she was arrested and charged for battery. Officer Parker did notice that the victim, Miss Roberts, did suffer lacerations to her face as well as a busted lip as a result of the attack. Your Honor, the state's recommendation for count 1 is going to be 12 months to serve, 30 days, balance suspended. The defendant is to stay away and to have no contact with the victim. Count 2 will merge, and also for the court situational awareness, the victim, Miss Deosha Roberts, is on, and she would like to give a victim impact statement.
All right, Ms. Roberts.
12 months.
Hold on a second. Ms. Roberts, unmute and raise, okay, raise your right hand for me. Solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, tell me what happened.
So I am a janitor at the Atlanta Hartsfield Airport.
Yes, ma'am.
Me and Miss Miller doesn't know each other. We never had any encounters with each other. I don't know what really happened. Honestly, I was walking to a post to go clean, and then I was struck from behind. I was walking past, and I was just struck from behind. I heard her say, "Bitch," excuse my language, and then that was it. Just felt the hit, and then I got ready to try to run from her, and she got ready to come behind me, and then I turned around and I started fighting her back because that's it.
All right. Well, I'm so sorry that that happened to you, Miss Roberts. Especially on your job, you minding your own business. Thank you for your statement, Mr. Lynch. Anything on behalf of your client?
Judge, nothing at this time. I would just ask that the court accept the recommendation from the state.
All right. So, Miss Miller, I'm going to sentence you to 12 months to serve 30 days. Balance will be suspended as long as you have no contact with Miss Deosha Roberts, and you cannot go back to Hartsfield-Jackson Atlanta International Airport for the next 12 months. Do you understand?
Okay, so how am I gonna get home? That's or to where
Where's home?
Philadelphia.
Okay, you might have to take a bus, ma'am. You cannot go back to the airport. Do you understand? All right. All right. Thank you, Ms. Roberts.
Judge.
All right. So that concludes the jail calendar for today. We'll have the trial calendar starting in about 30 to 35 minutes. Thank you all. Thank you, Ms. Roberts.
Excuse me, Judge. I'm
Yes.
sorry. Was that last plea, was that a guilty?
Yes, yes, ma'am. I'm sorry.
Thank you.
It was guilty on count 1, count 2 merges. All right. Thank you all.
Thank you, Judge. Thank you, Ms. Roberts.
Thank you.